For everyone.
Okay, can everybody hear us? Somebody could unmute yourself and just let us know.
Yes, we can hear you.
Awesome, thanks, Mark. Just give me one sec, okay. Okay, so welcome again, everyone, to our latest installment of the Lunch and Learn program. We have here today with us our very own Greg Hawrysh. He's going to be presenting today on sort of trial preparedness. It was the topic technically is motion sickness. But he'll talk a little bit about some of those types of issues. I was just mentioning it's, I think, related mostly to criminal, but some of the same principles do carry over for family matters and child protection, potentially. Just to give you guys a little bit of background about Greg, he was actually called to the bar in 1988, moved to Dauphin and initially had private practice out there. He joined Legal Aid in 1992 and then transferred to Winnipeg in 1995. He's lived through a lot of interesting times. He mentioned a Crown attorney pushing his law partner through a window. Was that Wilford?
Wilford and Irwin, yeah.
Yeah, I recall that. Greg's a former bencher for the Law Society. He's been to all levels of court in Manitoba. He's been to the Court of Appeal around 20 times. He delivered lectures to various community groups, including things like Law Day and high school law classes. And he's going to be doing an upcoming presentation regarding Selkirk Mental Health Center. He is currently the supervising attorney at the Riverwood Community Law Center, and he is also general counsel for Legal Aid Manitoba. He is currently as well counsel for over about a third of the annual cases that appear in front of the Criminal Code Review Board. So he does deal, he's our sort of resident expert in regards to,
Crazy people.
yeah, essentially. So, and with that, I'll pass you on to Greg.
Well, good afternoon, everyone. I'm glad to see that Mario, hello up there in Thompson. Of course, I figured you'd call in. It's everyone, you can put your pens down. I just want you to listen. I'm going to be listing case names. I'm going to be listing, case names, and at the end of it all, I'm going to ask you to email me, and I'll send you the list of cases, and also, most importantly, for those of you who are stick around to the end, I have count them, four sample motions, the notices, the affidavits, the factums, whatever you want to call them, that are filed in support of an affidavits and such, so that they will be of some very practical use to you if you're contemplating, let's say, making a Jordan motion regarding delay in a case. So they will be of some relevance. And that way you can leave today, contact me, I'll send this information to you, and you'll be able to redraft your motions or draft some motions over the weekend so you can hit the ground running on Monday, right? So anyhow, it's so just sit back and listen to some information on motions. Now, the root or the basis of my presentation was given, I suppose, in a seminar that myself and Ms. Dowell and Marcel Marion attended last April in British Columbia. It was put on by the Canadian Bar Association chapter out there, which is a very active chapter. They put a lot towards legal education. Of course, they have thousands upon thousands of lawyers out there, so they have the resources for that. Always check them to see what materials they have. You may find something worth attending or worth looking up. Their day of the day-long conference we attended was called Motion Sickness, and I can tell you by the end of it, I was getting quite sick of it. It's not to be frank, not the most exciting topic, but I'll try to do my best to keep your interest for the 45 or 50 minutes that I'll be speaking here. As usual, and if you've ever attended any of these seminars before, especially in British Columbia, they always like to give you a made-up factual scenario, and then to which you apply the law and identify the principles. And of course, being British Columbia, it's everyone I've gone to, it seems it has to have some sort of risque sexual element in it. So I guess that's to keep the interest up in a otherwise boring topic, or not exciting topic, I should say. So I won't give you the actual scenario that they gave us, but I will discuss the reasonings and the rulings and such that came through here. Much of the lecture and the most important parts of it, I submit, was found on the information relating to disclosure. So that will be the primary focus of today's presentation. And I'm going to give you some tips on effective case management from my perspective throughout the course of my presentation. And of course, as I mentioned at the end, sample precedents on Mills application, a Jordan delay, a Corbett application. And you might say, what are these applications? You'll see. And I'll mention them. There's also, because of course, this was a British Columbia seminar, a slant on British Columbia cases that they mentioned to us. And I'm going to take you through in detail at least one or two of these cases and make passing references to others to illustrate some of the points. And like I said, I have the case citations here. Don't even bother writing them down, and you'll get them all at the end. So firstly, I suppose, when do you start thinking of motions? And in my opinion of many others, I think, is the first time you start reviewing the disclosure. I know it's tempting, like a cheap novel, to skip around to the back and see who did it. In this case, did your client make a statement? What's his record? Any co-accused, that kind of stuff. No, read through it carefully. Start looking, is there a Section 10 argument, a Section 8 argument, perhaps, that you might want to consider? Go through it and then start identifying the potential issues that could be raised in defending your client. For example, if there's co-accused statements, you might want to look at getting their criminal records. In fact, if they've been in jail, you might want to get their institutional records, which is a form of third-party disclosure, which we'll discuss later in this. And of course, if your client has a record and you're contemplating calling your client, you might be looking at a Corbett application. But all of this are contained in some of the materials that I'll be providing to you later. So make brief notes of these points. Keep the issues alive in your mind. And in the months to follow, you may hear about a case that's relevant, other developments that have come through that may affect that case, so that you're always thinking, always having this in the back of your mind on that. In case the law changes as well, be aware of that. Now, those are some of the first considerations. Now, I want you to look at what's there. Also, I want you to look at what isn't there. Okay. Medical reports of your client, of the witnesses, of any other people that may have been involved. I can't see others, the complainant certainly. And the 911 call, transcript of that. Thanks, Morgan. Photo packs. And of course, now the new thing, which is tying up all of our storage space, body cam footage. It's going to be a big thing. A lot more disclosure is going to be coming out to us now. These files are going to take a lot more time to do it properly. Now, why are you doing this? Why are you getting these materials? No, all of you, with the I think I'm the only one here. All of you, I'm sure, got your call after Stinchcombe, the 1991 seminal case from the Supreme Court of Canada. Again, don't write this down, but I'm sure all of you know this. If you don't, I'm worried. Which Stinchcombe deals with the Crown duty to disclose information to the defense. You'll hear the terms all fruits of the investigation and obviously relevant information. And even if it's not information that may be called by the Crown at trial, it should still be disclosed to the defense. Whenever you read a case involving disclosure, they're going to mention Stinchcombe. Then they might mention McNeil. Then they might mention Gubbins, which is a 2018 decision of the Supreme Court of Canada. These seem to be the leading cases right now on disclosure. Now, as I said, Stinchcombe, believe it or not, is 1991. And the law is still evolving. I think it's gotten to a pretty good part right now, but they're still fleshing it out. Some of you may wonder, well, what happened before Stinchcombe? What happened prior to 1991 and Manitoba prior to 1992 or 93? Because they seem a little slower to adopt these principles out here. Facetiously, I suppose, since I got my call prior to 1991 and practiced criminal law for a few years. The old story was you go to the Crown Attorney and ask for disclosure, and they'd say, disclosure, go ask your client what happened. And so then you had to work from that. You get a couple of pages, and that would seem to be about it. You'd get witness statements eventually, but you wanted a witness's criminal record? Good luck. You wanted other information? Eventually you might get it, but it took forever, and it wasn't provided to you as a matter of right. There was a case I was involved in one of my first big cases. It was a church arson case from Dauphin, where the case involved my client who had allegedly burned down one of the big Ukrainian Catholic churches in Dauphin. It was a very high-profile case. The community was very upset. The only case against him was a statement from the evidence against him consists basically of a statement made by his younger brother. And in that case, I'm trying to think back now because it's been well over 30 years. My client was committed to stand trial at the preliminary hearing when I took over the case. And we were getting it ready for Queen's Bench for trial. I chose the jury, actually challenged for cause for the juror members. And then we had a pretrial in front of the judge who was going to be coming up from Winnipeg and obviously did not want to spend a week in Dauphin if he could find a way out of that. So while we're on this phone call, three-way phone call with myself, the Crown Attorney, and the Queen's Bench Justice from Winnipeg, we're discussing the elements of the case and the number of witnesses and what admissions could be made. My law partner kept whispering to me, going, "Tell them that the witness has been charged with perjury." I'm trying to, tell them it's charged with perjury. Tell them it's in relation to this case. So finally I said, "My lord," very timidly, because I'd been a lawyer for all of 6 months by then. "My lord, I've heard that the main Crown witness, the brother, has been charged with perjury in relation to the testimony he gave at the preliminary hearing when he recanted his earlier testimony, or his earlier statement, and that the Crown has charged him and is prosecuting him this past week." And the Queen's Bench Justice heard that, and you can picture him turning red at the other end of the phone line, yelling at the Crown, saying, "Is this correct, Mr. Crown? Is this correct? You're charging with perjury? That's the only witness?" And the Crown timidly then said that we'll be entering a state of proceedings. Now, why was that information disclosed to me? I got it third hand from a lawyer, my partner, who knew everything that was going on in the courthouse because he knew everything that was going on in the courthouse. Why hadn't the Crown disclosed that to me? Very relevant. You can look at the history of, I see many of you, thankfully, are recent graduates, and I'm sure many of you have taken some of the specialized courses dealing with criminal law at the university, including wrongful convictions. And Manitoba has a sad, sad history of wrongful convictions. I won't single out the Crowns involved since they're deceased to a large part, but a lot of this was based on inadequate disclosure. And not just not seeking out the disclosure, actively hiding the information in the file, hiding the details about any arrangements regarding plea bargains that have been made with witnesses that were testifying for the Crown, for example. Very, very sad. And of course, we have a number of overturned convictions as a result of that. So, Stinchcombe, McNeil, Gubbins, they're all designed to prevent wrongful convictions. And of course, there's the Section 7 rights involved here. You have the right to make full answer in defense to the charges that you are facing. Now, specifically, I said that I'd be reading out the definition of first party disclosure again. Just listen. Don't take notes, please. First party disclosure. The Crown has a constitutional obligation to disclose all fruits of the investigation or other obviously relevant information in its possession or control. If there is a reasonable possibility that withholding material could impair the accused's right to full answer in defense, disclosure is required. If alerted to other potentially relevant material, the Crown must make reasonable inquiries of other Crown agencies, including police. The Crown refuses to disclose, it must justify the refusal by showing the information is clearly irrelevant, privileged, or otherwise governed by law. That's the definition of what first party disclosure is. There are three main types of disclosure. First party disclosure, which I've just read to you, the Stinchcombe principles, McNeil, Gubbins, all that. And of course, McNeil, of course, dealt with police misconduct. And as most of you, well, few of you, may be receiving information from the Winnipeg Police Service recently regarding misconduct of some of their police officers and how it relates to some of the cases they're involved in before. Gubbins, 2018 Supreme Court of Canada, which I told you not to write down the citation, has a nice summary regarding disclosure. Like I said, it often helps if you go back to the latest big case regarding disclosure, because it summarizes all the cases leading up to it. So don't start your way at Stinchcombe and work forward. Start your way at Gubbins or any other cases that are recent and work your way backwards until you think you know enough. This dealt, of course, with yes, Gubbins was dealt with breathalyzer manuals and such. They had one ruling in provincial court, one ruling at the Court of Appeal, and then of course they went to the Supreme Court of Canada, where they said that just to quote the head note here, the breathalyzer maintenance records are subject to the rules applicable to the disclosure of third-party records, which we'll get to. As such, in order to obtain disclosure of the records, the accused were required to show the records were likely relevant in this case, which they failed to do so. It then goes on to say the disclosure of first-party records, of course, subject to the Stinchcombe regime, and what the Crown's duty is on that. With third-party records, the O'Connor regime. The accused has to make a court application for that. And the burden on the accused to show the accused is likely that the record is likely relevant. And so it's a nice case to decide to look at when you're trying to decide what type of application you'll be making. What I liked about the Gubbins case was the dissent, saying that the appeal should be allowed and that the maintenance records should be subject to first party disclosure rules from Justice Cote, saying they're obviously relevant in rebutting the statutory presumption of the accuracy of an approved instrument. So I like that definition, but obviously I guess it was a 8-1 against, so you're not going to see that as the state of the law. But anyhow, it's a nice case to read if you want to know about the latest on disclosure. Start at that case and you can work your way back if you wish. So reference, as I indicated, reference was made to third-party records, the so-called O'Connor application. Now, to deal with the definition of that, I'll give it to you. Like I said, just don't write this down. Just sit back and listen, please. Generally, the accused must apply for private records in the possession of a third party who is not the prosecuting Crown or investigating police force. For example, this might be the breathalyzer manuals or perhaps the maintenance records. The accused carries the burden of showing the records are likely relevant, meaning that there is a reasonable possibility that the information is logically probative to an issue at trial or the competence of a witness to testify. An accused serves interested parties, including those with a privacy interest in the records, with notice of the application. The records holder is also served a subpoena compelling them to attend a court with the records. Now, of course, there are two stages. I'm just going to digress for a minute before I get to the two stages of a third-party application and remind you that when you're looking through your disclosure, read the information. Just don't say, okay, my client's name is in there. Read it very, very carefully. Look for the specifics of the offense. Look for the identity of people. Of course, your client's name, perhaps the complainant's name, sometimes the property owner's name. Also, verify the date that the information was sworn. Make sure it occurred that it was sworn, for one thing. Make sure that it occurred after, not before, the date that they're alleging the offense occurred on. If it's incorrect or missing, I suppose the information is a nullity and there's no charge for your client to face. A good example of this, many of you, I'm sure, know Ms. Stacy Soldier, who teaches at the University of Manitoba. And she articled at Legal Aid Manitoba. And during her articling, I gave her a case to do at the end under the supervision of Melissa Ferrens, one of our other lawyers here. Involved a domestic violence situation with the accused allegedly, they were smashing the windows of her boyfriend's house. Her boyfriend rented the house. They charged her with smashing the windows, but they listed the name of the landlord, which is fine. I mean, it's his windows. But nobody thought to call the landlord to prove they were his windows. So I said, this is a possible defense here. When you go there, ask questions, much like you would in like, first year criminal law class and evidence class. Ask questions about the lighting. Ask questions about your ability to observe. Ask questions about how well you know the individual. Put up a smoke screen because you don't want the crowd to find out what your actual defense is. And she did an admirable job of it. And at the end of it, just before the Crown closed their case, she took a break to collect her thoughts. And according to what they reported back to me, the Crown attorney was talking to the officer going, I don't know what the issue is here. It seems like a straightforward case. What are they going to argue? And then I think he realized it when he read the information. And they made a motion for no evidence, and they were successful. So always read the information. I have an interesting case right now involving, sadly, animal cruelty, but the Crown has said they're rewording the information. I don't know if they spotted this issue, but it's a different standard applies if it's a kept animal or not. And this involves a stray cat. Stray cats are still protected, don't get me wrong. But if they're charging it as a kept animal, they have to prove it's a kept animal, which it isn't. So now, obviously, these are the types of defenses you do not disclose to the Crown attorney prior to trial, because it's simply enough to amend or to call a witness to correct that information. But the upshot is read your information, do it at the front of the trial or the front when you get the initial disclosure, and prepare some defenses for that, so, if necessary. I've always wanted to find a case with an unsigned information. I hope some of you have, because that would be like a nice cherry to have in your career, that you were so diligent. And you'll see some lawyers, especially some of the older lawyers, actually inspecting the information prior to court, prior to their trial. And that it could be, that actually is the reason why. So we're talking about third-party records, getting back to that. There are two stages. Stage one is to determine whether the records are likely relevant. And stage two, determine the actual relevancy and balance other interests such as privacy. And that, of course, this is the O'Connor test that we're talking about. Now, you're going through your disclosure, sorting out what there is, and you might notice that you're missing some disclosure. What do you do? Well, you should be doing this at the very close soon at the outset of your case. Send an email to the Crown. Make it polite, make it professional in tone, and provide the Crown with sufficient detail as to what you need. For example, you might say, regarding our case of that you're the prosecutor on, such and such, I am defense counsel. In reviewing the disclosure, I note that I have not received the medical reports for the complainant, or I would like the criminal records of any witnesses that you intend to call. Please provide them to me. Make your disclosure specific, make it polite, and make it early. Provide sufficient detail for the Crown to respond to you. For example, just instead of saying all the witnesses, just say, I anticipate you'll be calling these witnesses, list them by name. Please provide me with their criminal records and details of any outstanding charges that they may be facing. Then, and only send. Do not then say, by the way, in another case that I have with you, send me this information, or can we resolve it? Separate it out, one email per case, one case per email, I should say. Why is that important? Because if you're ever attaching those emails to an affidavit, you don't want to look like a fool, and you want to narrow the issues so that you can say that the Crown had specific notice of this. It wasn't buried somewhere in an email. It was an email directed to this very issue. And like I said, keep it professional. Don't say, see you at the Legion on Friday or something. Just say, you know what, I await your response in your earliest convenience. We have this matter appearing in date set in court on whatever date. Okay, it's important. Because you want to establish delay. Okay, delay attributable to the Crown. And be mindful of Jordan timelines. Make a disclosure request in a timely fashion. The clock is always running. Remember that. So to communicate with the Crown by email, like I said, be professional. Most of you who are lawyers are members of the CDLA. You should be members. It's a great organization. Our own Kevin Sneesby is on the executive there, and he's always trying to boost membership. Michael Dick, one of the members of the CDLA, sent out an email recently detailing with a handout or an attachment called Improving Digital Communication with the Manitoba Prosecution Service. If you don't have that, email me. I'll send you the link. It's a very good article on the best way to communicate with the Crown. It basically says, send it to the Crown, don't send it to their assistant, because it could get lost, has to come to the Crowns themselves. Who do you request it from, what you should say in it, and that kind of stuff. It's only about 4 or 5 pages long. It was very short manual, but certainly one worth knowing about. So like I said, it also has sections on arranging trial dates. And for Jordan purposes too, let's say you have 3 or 4 co-accused. The first lawyer says, I'm only available, June 20th, ignoring the dates in April and May. So instead of just saying, well, I can do June 20th, just say, you know what, I'm available on these dates. Because now the Crown knows if delay ever comes up, you say, I was available. The Crown could have chose to split the prosecution, proceed separately against my client if delay was going to be an issue. They knew I was available, but keep that in mind. like I said, contact me and I can forward that on to you. Anyhow, back to the O'Connor application. So we just talked about, excuse me, stage one and stage two here. Stage two, of course, is stage one is determine whether it's likely relevant. Stage two is determine the actual relevance and balance the other interests such as privacy concerns. The third regime is the so-called Mills regime, contained in the Criminal Code, section 278.1 to 278.9. Of course, the case comes from R versus Mills, 1999, Supreme Court of Canada. Main principles there. And also a nice case that followed from that is the Quinnell file, Quesnelle. Don't write that down. Interesting enough, the seminar that I was at in April had the spelling wrong. So when I was researching this, I looked all over for that spelling and realized that they were wrong, not me. Records in the context of a 278 application are defined in the criminal code. No record is to be disclosed unless ordered by the court. The exception, of course, is where the complainant or witness waives the process. I haven't had that happen. The Quinnell case, which I made reference to for a moment. A lot of pieces here that I wanted to do. I'll get back to it later, I suppose. The how do you know which regime applies? Is the material sought covered by the Mills regime? Is it, let's say, counseling records of a complainant in a sexual assault case? Use a criminal code procedure. No. Go to the next question, which is the material part of the fruits of the investigation or obviously relevant? If yes, then the Stinchcomb principle applies. If no, then the O'Connor application should be made. Here's an interesting procedural point here. You're going through a case with your client. You're reviewing it. You're debating, what motion should I make? Let's say your client's found in a car, and in that car, the usual guns and drugs. Could be a problem with a lot of the cars that people borrow from friends these days. The police stop them. They find this stuff. Now, do you make your client may be a passenger, for example. Do you make an argument based on the search and seizure? Or maybe you just go and say, I don't think they can prove possession. And you don't make that motion. Should you let your client decide? Well, if you don't make the motion, your client's acquitted on the basis that they can't prove that your client was in possession of it. Your client's acquitted, walks free, and of course, they may or may not thank you, or as your client might say, well, of course it was never in my possession. All you had to do was just mention that instead of all the work you did to get it to that point. However, if convicted, client then says, well, why didn't you make a motion to exclude the evidence? Or most of them likely, his counsel on appeal would say, why didn't you make a motion to exclude the evidence? Like I said, it only arises in the event of a conviction, not an acquittal. And then if that happens, be prepared to get nasty letters from appellate counsel, possible from the Law Society over your conduct, asking why, because the question may be asked, why was this motion not advanced? So to defend yourself from allegations of incompetence, make written notes on these points, make written notes regarding your decision. Consult with your client. Explain the options to them. Perhaps have a witness present when you're having these discussions. And this is one of those, and some people say take written instructions, some people say not to. I'm in favor of taking written instructions at many times throughout the case, such as deciding whether to call a client or not. Why? If your client's convicted and you didn't call them, you're going to say, well, if I had told the judge it wasn't me, I wouldn't be sitting in jail. And then they go to appeal, and you spend a lot more time defending yourself from the loss side in the Court of Appeal than you did defending your client. The going back to another Dauphin story, written instructions started to come into favor, I suppose, early 90s. I went to a seminar, one of the Federation seminars, and they talked about taking written instructions from clients on guilty pleas, and they talked about some sample cases where it was discussed. So I had a client come up and was trying to break into a house. He was on the roof of a house. There was a young girl inside, so it was potentially a dangerous case there. I believe Crown wanted 15 months. I was going to ask for 6 or 9. And I explained the information to my client, said, you have a potential defenses here. And he didn't want to, said, no, I just want to plead guilty. I said, well, you could be looking at big time here. He said, no, I just want to plead guilty. He said, okay, then here's my written instructions. And he read them and signed them. And they were based on one of the cases I'd read about right on point, which said, I so-and-so am facing these charges. My client explained the circumstances to me. He's explained my potential defenses, including the issue of intent and whatever it was, and has told me that he is keen and eager, I use those terms, to fight this case. I don't know why that was in one of the cases that I'd read, so I figured I liked it. And however, I've chosen to not follow that advice from my lawyer, and I'm instructing my lawyer specifically to enter a guilty plea. So we did the sentencing, of course. Same lawyer that pushed my partner through the window. And my client got 15 months or whatever. And so that's the end of it. I collect my $200 in legal aid money back then because I was in private bar. A week later, I get a letter from a firm in Winnipeg saying, why did you plead this guy guilty? Send me the reports. And so, I mean, there I am thinking my legal career could be over. And I said, well, here you go, Mr. Lawyer's now deceased, so I can say this. But here's the police reports. As you can see, the issues were such and such. These were the defenses which I laid out to my client. However, he chose not to follow the advice. In fact, here's my 2-page written instructions from the client on these exact points. And that was the last I heard of it. So thankfully, protect yourself, because in that case, that was a lot of hassle to earn $200 if I'd had to start defending myself from allegations of incompetency from the Law Society, the Court of Appeal, or whoever. Now, I'm going to go through so take written instructions in a case like, in many cases, but certainly you might want to consider that when you're making the decision as to what motions to advance, just because you don't want to go in front of the Law Society. You don't want to go in front of the Court of Appeal. You don't want to write letters and have everyone review your conduct of the file. Hasn't happened to me, but it's happened to lawyers that I know of, and they did not like that at all. I'm going to refer you now to the case of R versus Klein. Of course, another British Columbia case. As I said, there was a slant of BC cases. 2024 from the BC provincial court. Not very persuasive, it's a provincial court, but it's a nice case. Why is it nice? Nice, sets out the principles nicely, and it's very relevant to situations that we deal with on a daily basis here at Legal Aid. Mr. Klein was charged with uttering threats, domestic situation. And then a few months later, what follows a charge? A breach allegation of communication. So he went to court and his lawyer filed or was asking for disclosure. I like the analysis contained in this case over the how they categorize the types of disclosure. They said there were 4 types of evidence or information that the defense was seeking. One of the interesting parts in here. Oh, just basically a bit more background here. He was alleging a pattern of a setup by the complainant, a pattern of harassment, because there were concurrent family court proceedings. I'm sure we've all seen this in other cases. And also that every time he had the child for a visit, she would phone the police and complain about him. And the police would have to come out and interrupt the visit, which was disruptive to the visit and distressing to the child. Anyhow, that was part of the what he wanted disclosure of, was that information. So he filed a motion, and one of the documents filed was an affidavit from they say a legal assistant. I'm going to say that it was probably an articling student, but it was contained a number of disclosure requests to the Crown. Remember, I've told you about sending those emails to the Crown, being professional. Why? Because they're going to be reviewed by other people. And there were at least 4 or 5 or more specific disclosure requests made to the Crown regarding Mr. Klein's case. Anyhow, there were 4 different types of evidence here. 911 call and transcripts related to police reports that the 2 offenses he was charged with. Any documents, audio, video recordings, transcripts, police notes, and any other source material pertaining to the information provided by the complainant to the police for the purpose of preparing 2 intimate partner violence risk assessment documents, which I assume are similar to what Victim Services does here. And then this is another interesting point here, because they had a prior history 6 years earlier. All police file materials, specifically any reports to the Crown regarding these police notes, audio recordings, etc., from 2016, 2017, 2018. They actually listed the police file notes. And then any police files created in relation to the complaints made by the complainant about the accused since October 20th, 2023. So Brown took the opinion that, yes, some of this is Stinchcombe disclosure, we'll get it over to you, although it took them forever. Some of it, they said no, that categories 3 and 4 were in the hands of a third party, were not fruits of the investigation, and that it should be an O'Connor application. And anyhow, to jump to the end here, the police said that no, most of this is third party, or pardon me, is Stinchcombe matters, and that should be disclosed, basically, or disclosure of everything with some caveats on that. Very good case for good reasoning in that. Very favorable ruling. So keep that in mind if you're going through something similar, trying to decide what evidence should be subject to a Stinchcombe or an O'Connor, perhaps even a Mills application. I'm going to speed it up a little bit here. I was going to discuss the client case in much greater detail, but I don't want to lose some of my time here. Now, how should the disclosure be provided? Well, it should be in a accessible format. Sometimes in the case of R versus Cuffey, which is a case that I'm providing to you, 2020 Ontario Supreme Court, um, is sometimes too much is too much. That it has to be, just can't be there and given to you. It has to be in a format that's accessible, that's searchable, and that's accurate. In the Cuffey case, they found out that some of the information was filed under the wrong headings, for example, and that unwieldy electronic disclosure is not satisfying the disclosure requirements. To be meaningful disclosure, the disclosure must be accessible. That means organized and searchable, be capable of identification, must be able to enable trial preparation, and be accessible in court. So the one of the cases that I looked at in preparation for this that was cited to us, I didn't cite it in here, but they were putting undertakings on council regarding the disclosure and to the whole separate issue. But there was a lot of disclosure, and the one of the lawyers balked, wrote back to email the Crown back and said, "No, I'm not prepared to accept this. I do not want to have my client living at my office." Which is, and I guess the court found that interesting enough to include the contents of that email in their judgment. But again, the point is that it should be a disclosure that is accessible and identifiable. Now, the issue becomes, what if council can't view it? And here's some local flavor for you. The 2007 Piaskowski case. I'm not going to cite this to you. It's from Manitoba, from Justice Sinclair, as he then was. The large-scale investigation. There was CD-ROMs and DVDs. No, this is 2007, so that was breaking disclosure back then, 19 years ago. I call it the old person's case because the number of lawyers that said, "We can't read this. We can't figure it out. Give us training, print out copies for us. Who's going to pay for the copies, et cetera, et cetera." And it was voluminous disclosure according to the case. So basically, the court said, now, you'll learn and you'll find that this will be a useful tool for you in the future. And they declined to order production of written copies, but said they could ask legal aid for payment if you, I don't know how that came up, but it did. And with time, you will be better. Now, I can say this now because I looked at the lawyers involved, and several of them sadly are deceased. And the third one I saw a couple of months ago, he was flying to Hawaii for 6 months. So these are quite old lawyers that were involved here. So one thing that I like to do when you have disclosure, print out your witness statements. If you have to contradict, or if you want to impeach the testimony of a Crown witness, for example, hand them a copy of the statement. And this is why you should have several copies of it, because if you haven't taken the time to separate it from the big type disclosure that you might have, or stapled disclosure, and you're flipping through 80 pages to find a 3-page statement and handing it all to the witness, it's very unprofessional looking. And don't provide them with the statement that you have, that you've marked up, containing all the inconsistencies. Give them a clean copy so that they cannot try to guess what you're going after and try fighting you on those points. There's a book, Fundamentals of Trial Techniques, page 234, I believe. This is a book we got in law school many years ago. Don't ask me what edition it is. But it has a nice way, a nice couple of pages on how to impeach a witness by referring to prior statements. Stuff like, you signed it, you told the police officer, yes, you signed it, this is what you said, yes, words like that. I mean, you should, a nice primer to have before you do, before you start going after a witness and grabbing them by the jugular. But certainly have a clean copy for them. have a copy for yourself. And so that you can follow along and point them to what specific lines that you're making reference to. Excuse me. Another good case I like, Hawrysh Pascal, 2020 Ontario Court of Appeal. Again, it's in the list of cases that I'll be providing. Interesting case because it deals with disclosure of criminal records of witnesses. In this particular case, a crucial witness against Mr. Pascal's sexual assault charge had outstanding charges and criminal record the Crown did not disclose, which is a departure from standard yet incorrect local procedure. Come from one of the notes here. But in that case, the witness significantly changed his testimony from what he had provided to the police in a statement and what he testified to. And it was far more favorable to the prosecution, of course, the second time around. The defense had not been given details of the criminal record or the pending charges of this witness. So the appeal was allowed, a new trial was ordered. Interesting, it was, this is 2020, went to the Supreme Court of Canada, the Crown appealed, appeal was dismissed, or leave was not granted. And if you look online, actually, this is interesting. They have a memorandum to the chiefs of police in Ontario from the Assistant Deputy Minister regarding how to deal with Pascal and what should be disclosed. It's going back 6 years now, I guess. But it should be include the criminal record for all Crown witnesses in the Crown brief. Check for outstanding charges laid by the investigating police service against Crown witnesses and advise the Crown of their existence. An investigating officer who is personally aware of outstanding charges laid by a police service not involved in the investigation must advise the Crown of the existence of those charges. Provide occurrence reports for the outstanding charges to the Crown upon request. Assist the Crown in inquiring into the existence of outstanding charges laid by unrelated police services if requested. So not only adult records, it's youth records as well. So it's a nice procedure they have there. So what happened? I don't know, my experience has been, I asked for these records and you ask. And you ask. And what happens is that they say, yeah, we'll get it to you. And then the morning of trial or the day before, you get the criminal records. Okay, and that's not timely disclosure. Why? Because you want to go through these records. Let's say they have a record for or conviction for, well, certainly perjury would be useful. You'd like to know more details about that. But you can go a bit further, depending on the case that you're dealing with. Let's say you want to go have your articling student, who's got time, I imagine, go listen to the sentencing transcript for some of these witnesses, where they might be talking about the problem that the issue that they've had an issue with intoxication. Look, check the timing of it. Says, well, is this when you were, for example, supposedly the sober witness to this to the allegation that you're a witness in, or that you're talking that you have an issue with drug and alcohol addictions? You know, information that you might want to use. Okay, back to and yeah, listen to what their defense counsel have said. If they say they don't have a drug and alcohol issue, say, well, your counsel did. Did you tell them that? They say, no, my counsel's making up. You know, they told the counsel that, and anyhow, it goes to their credibility. But going back to types of what happens when you have a self-represented accused. Well, that's poses a problem. There was a case years ago. Number of Hell's Angels were charged. They're kept in the remand center for a number of reasons. They didn't have adequate or counsel, and there was a Robotham application pending, and legal aid app was sending a bunch of us down there, appointing us to go down and see them. And they had access to a room with materials on certain hours of the day that they could review the disclosure, because it was in an electronic format, but they could not take it back to their cells. Interesting point. So I think there were 7 of us sent down to see these people. I actually went down and spoke to my client, and one of the things they did, which was very demeaning, was they had a questionnaire that they had for every lawyer that was going to be assigned to them to fill out. And he started on this, and he said, well, I want references. And I said, well, I'm not going to disclose references, clients' names, because that's confidential. You ask around, go ahead, I don't care, but I'm not going to breach solicitor-client privilege here. And which I don't know if he understood that point, because he said, I'm a professional trainer, I always give references, and well, I don't. And then the other questions, which said, now tell me about your drug and alcohol use. And I said, I'm not going to answer that. I didn't tell him to, well, obviously I'm sitting here, so I didn't tell him to go fuck off. But so I said, I'm not going to answer that. He said, why not? I said, I wouldn't even answer my parents if they asked me that question. It's personal and it's rude, it's insulting. So we chuckled and we parted. And anyhow, I can't remember. Anyhow, he ended up getting other counsel appointed, I think, through the court. Takes us now to the Feldham case 2024 Saskatchewan King's Bench deals with a Celebrate extraction. That's where they take the contents of a cell phone. Then the Dadman case, which I'm also citing here. Basically, you got to make a third-party application, it appears, and also be aware of the breadth of a cell phone search. I'm going to wrap this up right away. The resource material for this, thankfully, John Robbins of our office was very up on these things, has encouraged us relentlessly to purchase this book, which I did. It's Practitioner's Criminal Precedents, 7th edition by Alan Gold. I use Alan Gold's criminal code. I really like the way he prepares and his view of the documents and his view of the criminal law. This book on criminal precedents, which I'm holding up, very good resource, not just for the forms, of which there's many, or almost anything, habeas corpus, for example, but sample affidavits and briefs. I recommend it very highly, and from it, I have copied several examples. If you email me, I'll be able to send the copies out to you. Remember, they're samples. If you like them, I encourage you to have your whoever's in charge of resources at your office to order this book. It's only a few $100s, and it's well worth it. It'll pay for itself in many saved evenings and afternoons of research material, and you'll be putting out a much better product than you might without it. There's an O'Connor application that I'm sending to, which is one of the materials that you can request from me that I have. It deals with the getting the records of remember O'Connor, third-party application, the records of a correctional facility for witnesses. Okay, seems relevant. There's a Mills application, which of course, remember that statutory regime, section 278 and following of the criminal code. There's an application for Mills contained in this material as well. There's a Corbett application regarding your client's criminal record and how you don't want it mentioned to the jury. That's in here. That's notice of application and affidavit, and actually a sample factum on those points. And most importantly, which dealing with the issue of delay as we're about to run out of time here, a Jordan application regarding your client's Section 11 rights. There's a notice of application and emergency alert. I did not schedule that. It's Alan Gould telling me not to read out his materials to people. Anyhow, notice of application and a sample factum. And of course, these factums are actually quite accurate, and the statements of case law in there and the reasoning is quite sound. Of course, I'm not going to disagree with Alan Gould, of course, but email me That's GR, you can write this down. GRHAW at legal aid, legalaid.mb.ca. Obviously, all of you know this. And I will send you the list of cases that I've made reference to. There's 11 of them. A link or a mention of Alan Gould's materials and the actual, there's a lot of it. The four different motions that I've just discussed here. And if you want specifically to, I can link you to the Michael Dick article or the paragraph, the material that Mr. Michael Dick was sending out regarding communicating with the Crown. I'm going to leave it at that. It's been an hour. It's quite frankly not the most exciting topic, but it's a very relevant topic. And I hope that all of you enjoyed it. If you have any specific questions, I invite you to look through the materials that I'm sending you and then perhaps contact me next week. And thank you very much.
And we will post to the recording of today's presentation as well as Greg's materials on the Lunch and Learn page. I've circulated that link a couple times. Does anyone have any specific questions? Feel free to either unmute yourself and ask or put something in chat.
I have a question actually, if you don't mind.
Yeah, Cody, great.
Okay, so I'm wondering if maybe it's not connecting in my brain, but I just want to make sure. Can we use any of the things regarding disclosure in that and the principles stated in King's Bench when it comes to family law situations? Or is it strictly for criminal?
The last family law case I did was my brother's divorce in 1991. Worked out all right. I do not know. I'm sorry.
Okay.
I cannot tell you. It would be nice because I'm certainly there's chock full of information here, and but yeah,
All right.
interesting. I can see how in a family case, I mean, if you could get, well, I know in CFS cases, for example, they often provide you with all these police occurrences or the number of times that the police have been called to a residence.
Right.
So I guess you could make a similar application based on, I don't even know, just fairness.
I mean, I would think that some of the principles shared, especially with disclosure, would transfer over. Specifically, just a quick highlight. I'm doing a situation where someone's objecting to their name getting added to the child abuse registry. So it's on a different, scale there. It's balance of probabilities instead of being, what they can prove and what they can disprove full out. But I mean, it's the burden of the agency to provide me with the disclosure. And I definitely just want to say that, what you shared today, I do think will be helpful when, if it does come to a time where I will have to speak with witnesses. So thank you.
Cody, I can say again, I similar to Greg, I was a criminal lawyer always, but from what I've learned about family law at this point in a couple of seminars that I've attended, there's a lot of overlap actually in case law, particularly with things like expert evidence or surreptitious evidence or, things like that. Exact same case law used at all levels for family or criminal.
Okay.
So, and I would also say, make the argument. You never know. You could make new law.
Yeah, why not?
Right. If there's nothing else saying something to the contrary, you never know.
They should do a lunch presentation with the family lawyers on this point.
Yeah, we do have a couple of things with the family lawyers. Anybody else have any other questions? I see people saying thank you to Greg.
Oh, well, thank you very much. I'm glad you guys hopefully enjoyed it. So,
anybody else going once? Twice? Okay. Well, on that note, I just want to say thank you, Greg, for imparting your knowledge on us today.
Hi, everyone.
And again, I will be posting this presentation and Greg's materials on the Lunch and Learn page. All right, everybody have a great day. Have a nice weekend. Stay warm.
Here's your door prize for attending.
All right. Thank you.
And they didn't photocopy the best, but
It'll do.
yeah.